Man a spider, man a spider, containing all that which is spider, spinning gossamer threads, entanglements for whatever is called for, rapscallions seized as if they were merely flying pests. Hark, for come forth does the man a spider. Now if you want to keep your happy mood, stop watching.
So gender is just a social construct, and believing in God is a crutch. When you mix them together and give them a whirl, what do you got? Atheist T-girl!
So the poem I just read today, the Shakespearean, Fox Shakespearean effort I put into making the Spider-Man song into a Shakespeare poem, has nothing to do with the video. I just felt we needed something fun before we got into this crap. If you want to stay happy, turn this off and go walk away. Think about puppies or something. Otherwise, stay tuned. I'm Alanis, and I'm also Atheist T-Girl. Today we are going to look at Georgia's House Bill 481, which was signed into law on May 7th. There are a lot of stories on the internet about what this bill does and doesn't do, so I thought it would be a good idea to go ahead and review the bill and see if it's as bad as it seems. Spoiler, it is monstrous. Before we get into the bill, there are some formatting styles that I need to cover to make the bill easier to understand. If you'd like to read more about formatting, please check my notes. I've put a link to instructions of how to read bills. Georgia and Florida, when writing a bill, will take the existing law that pertains to what the bill is about and then shove that bill into the part of the statutes. While doing so, there is 3 points of typography used. Anything with a strike through is something that was originally in the statutes or laws and is going to be removed if this bill becomes a law. Anything that is underlined, that is something that is going to be added to this law if they get the law passed. And any words without any strike-throughs or underlines, these are words that were already in the statutes, and they are still going to be in the statutes afterwards and will not be changed. I am not a lawyer, and I've not had any classes on how to read bills. During my campaign, I read a fair share of them, and I've also checked other reviews of this bill to make sure my conclusions are sound. But if there's a mistake on it, it is me and not my sources. There are 3 parts of this bill. Section 1, which is a listing of what this bill is intended to do and what section of the current law it is to replace. Section 2, a list of reasons why the writers of this bill think that it's the right thing to do. And Section 3 through 16, the actual text of the bill. There's very little in Section 1 that will not be covered better in my upcoming section where I do a fuller review of the bill. But I did want to talk about the name of the bill. Yes, the bill has a name other than HB 481. It is the Living Infants Fairness and Equality Life Act. Note up front that they are referring to embryos in uterus as living infants, which, while technically and medically wrong, it is a smart move. Because now you can give interviews in which you state that the opponents of my bill are people against living infants. And generally, that's up as high as a position as squashing puppies that you want to be associated with. So it's a pretty good move. Section 2 is a list of reasonings used to make this bill, and it will be helpful to read a few of them to give you a mindset of what the writers have intended. There's a link in my notes that you can read if you want to play along. 3. Modern medical science, not available decades ago, demonstrates that unborn children, SIC, are a class of living, distinct persons, and more expansive state recognition of unborn children, SIC, as persons did not exist when Planned Parenthood versus Casey in 1992 and Roe versus Wade in 1973. Please note that I will stop correcting the bill's misuse of language when they refer to embryos as children or other words loaded with connotation and without any scientific or realistic info, or I would never get through this whole bill. See, here they are trying to make the case that embryos are unborn, living people, and that this info was not available when Roe versus Wade or PP versus Casey were decided. Thus, the law is not covered by these rulings because this is new information. The 1 and 2 before the statements are laying down that the Constitution and the amendments state that all humans are equal and that all humans need to have due process. Number 3 makes the argument that embryos are humans, and then they state in number 4 that because of this, embryos are entitled to the same rights. 4. The state of Georgia, applying reasoned judgment to the full body of modern medical science, recognizes the benefits of providing full legal recognition to an unborn child above the minimum requirements of the federal law. I don't believe they took the medical science provided to them in good faith. I tried to find a list of people who testified for and against the bill in order to get an idea of what scientific and medical information they had to work with, but I was unable to find one. The closest I can find is a news report which lists some of the speakers and notes that most of them were against the bill. Quite a few doctors are listed, but I won't say that there were no medical opinions for the bill, as I can't find a full list. 5 is a statement that the Georgia Constitution also gives rights to humans. Then they use number 6 to tie all 6 of them together. It shall be the policy of the state of Georgia to recognize unborn children as natural persons. So basically they made a case that the law says that all people have rights, that they believe embryos are humans, thus embryos have these rights as well. Now we're going to move to the next part of the bill, and I will read it section by section and review those. Section 3 is covering the laws and the statutes that determine what a person is, and they are making changes to it. There are 2 big changes. First, they add a line to define what a natural person is. It is not an offshoot of Aretha Franklin's Natural Woman. You make me feel, unfortunately, as read 1-2-1, period. There are 2 classes of persons, natural and artificial. B. Natural persons mean any human being, including an unborn child. In addition, they declare all people, including unborn children, shall be included in census data. D. Unless otherwise provided by law, any natural person, including an unborn children with a detectable heartbeat, shall be included in population-based determinations. E. As used in the code section, the term 1. Detectable human heartbeat means embryonic or fetal cardiac activity, or the steady and repetitive rhythm contraction of the heart within the gestational sac. 2. Unborn child means a member of the species Homo sapiens at any stage of development who is carried in the womb. At least they got the right species right. This bill is really a thrust in 2 directions. It works to make the embryo a person in legal sense, and 2, clarifies that because the embryo is a legal person with full legal rights, it cannot be aborted. The heartbeat that this bill is often named after is a reference to when the legislators believe that a heartbeat in the embryo starts. Thus, this is when it becomes a citizen. Section 4 is where the laws on abortion and what is allowed is changed. Due to all the strike-throughs, this section is a mess. This is just a part of Section 4. Rather than show you the whole thing, remember you can see the unaltered version with the link in my notes. Here it is cleaned up. And I do really think that this part is important to read all the way through. So please put up with me. This is a bit of reading here. Article 5 of Chapter 12 of Title 16 of the Official Code of Georgia annotated relating to abortion is amended by revising Code Section 16-12-141 relating to restrictions on the performance of abortions and availability of records as follows. Quote, 16-12-141 A. As used in this article, the term 1. Abortion means the act of using, prescribing, or administering any instrument, substance, device, or other means with a purpose to terminate a pregnancy with knowledge that termination will, with reasonable likelihood, cause the death of the unborn child, provided, however, that any such act shall not be considered an abortion if the act is performed with the purpose of A. Removing a dead unborn child caused by spontaneous abortion, or B. Removing a ectopic pregnancy. 2. Detectable human heartbeats means embryonic or fetal cardiac activity or the steady and repetitive rhythmic contractions of the heart within the gestational sac. They sure make that sound so interesting. 3. Medical emergency means a condition in which the abortion is necessary in order to prevent the death of a pregnant woman or a substantial and irreversible physical impairment of the major bodily functions of the pregnant woman. No such greater risk shall be deemed to exist if it is based on a diagnosis or claim of a mental or emotional condition of the pregnant woman, or that the pregnant woman will purposely engage in conduct which she intends to result in her death or in substantial and irreversible physical impairment of a major bodily function. 4. Medically futile means that in reasonable medical judgment, an unborn child has a profound and immediate congenital or chromosomal anomaly that is incompatible with sustaining life after birth. 5. Spontaneous abortion means the naturally occurring death of an unborn child, including a miscarriage or stillborn, including a marriage or stillbirth. B. No abortion is authorized or shall be performed if an unborn child has been determined in accordance with Section 31-9B-2 to have a detectable human heartbeat, except when 1. If a physician determines in reasonable medical judgment that a medical emergency exists. 2. The probable gestational age of the unborn child is 20 weeks or less, and the pregnancy is the result of rape or incest, in which the official police report has been filed alleging the offense of rape and incest. As used in this paragraph, the term probable gestational age of the unborn child as meaning provided by Code Section 31-9B-1, or 3. A physician determines in reasonable medical judgment that the pregnancy is medically futile. C. In conducting an abortion, if a child is capable of sustained life, medical aid then available shall be rendered. D. No abortion is authorized or shall be performed in violation of subsection A of Code Section 31-9B-2. E. 1. No abortion is authorized or shall be performed after the first trimester unless the abortion is performed in a licensed hospital, in a licensed ambulatory surgical center, or in a health facility licensed as an abortion facility by the Department of Community Health. 2. An abortion shall only be performed by a physician licensed under Article 2 of Chapter 34 of Title 43. Oh, that was a mouthful. F. Health records shall be available to the district attorney of any judicial circuit in which the act of abortion occurs or the woman upon whom an abortion is performed resides. G. Any woman upon whom an abortion is performed in violation of this code section may recover in civil action from the person who engaged in such violations all damages available to her under Georgia law for any torts. H. Last letter, but it's got 5 points. It shall be an affirmative defense to prosecution under the article if 1. A licensed physician provides medical treatment to a pregnant woman which results in the accidental or unintentional injury to or death of an unborn child. 2. An advanced practice registered nurse or registered professional nurse, as such terms are defined in Code Section 43-26-3, or a licensed practical nurse, such term is defined in Code Section 43-26-32, engages in the practice of nursing to provide care for a pregnant woman which results in the accidental or unintentional injury to or death of an unborn child. 3. A licensed pharmacist engages in the practice of pharmacy, as such term is defined in Code Section 26-4-4, to provide care for a pregnant woman which results in the accidental or unintentional injury or death of an unborn child. D. A licensed physician assistant, as such term is defined in Code Section 43-34-102, provides such care to a pregnant woman which results in the accidental or unintentional injury of or death of an unborn child. And finally, 5. A woman sought an abortion because she reasonably believed that abortion was the only way to prevent a medical emergency. Everyone take a deep breath. We are done reading the long part of this bill. Now, what did all that mean? That was a lot of words, and I promise I won't be full quoting the rest of the changes of the law, but I felt it was important to put this full section here so it's clear that I am not using any of it out of context. When I first read this, I thought it was a terrible law, and the more time I've read it, and the more time I've had since I've read it, the worse it gets. Let's review a few parts. First, this section when it talks about medical emergency abortions. No such greater risk shall be deemed to exist if it is based on a diagnosis or claim of a mental or emotional condition of the pregnant woman, or that a pregnant woman will purposely engage in conduct which she intends to result in her death or in a substantial and irreversible physical impairment of a major bodily function. It should be noted that this bit was in the law before this bill, but still there should be a few things pointed out about it. First, it mentions that only a medical physical risk emergency is valid. It will not allow someone who is mentally unable to carry or birth a child to get an abortion. And then it states that this will be the case even if it is obvious as a result that this person in question will commit suicide or intentionally hurt themselves if the abortion is not obtained. The Georgia law puts the life of an embryo over the emotional state of a person, even if it means that person will commit suicide, which should be noted will end the embryo as well. Next, this section talks about an exception that allows an abortion after a 6 weeks period. Medically futile means that in a reasonable medical judgment, an unborn child has a profound and irredeemable congenital or chromosomal anomaly that is incompatible with sustaining life after birth. Basically, if the embryo will not live outside the person, then okay, it can be aborted. But the question must be asked, as is not specified here or anywhere else, how long out of the parent? It should be noted that many tests for genetic conditions such as spina bifida, skeletal dysplasia, hydrocephalus, Budd-Chiari, Tay-Sachs, and cystic fibrosis are only effective after 6 weeks. These are diseases that are not lethal, but some of them do require a lot of medical care, and there are some parents who will not be able to take on this responsibility. And then there are lethal genetic conditions like trisomy 18, which with the right treatment might allow a baby to live to 1 whole year before they die. As read, this law would state that a parent would have to deliver this child and then spend a year watching it die. Following this in the bill is an exception for rape or incest. The probable gestational age of an unborn child is 20 weeks or less, and the pregnancy is the result of rape or incest in which an official police report has been filed alleging the offense of a rape or incest. If you have followed the Me Too movement, you will know that all rapes are reported. And when you look at the shit that rape victims have to go through and how often it results in them being vilified, with the rapist getting maybe a slap on the wrist, it is quite understandable why they're not. Yet with this law, if it takes you longer than 6 weeks to realize you're pregnant after a rape, and this is very easy to do, especially if you have an irregular period, you will not be able to get rid of the embryo without going through the whole police process. In addition, it mentions incest. I may not need to mention it, but I will because there are people out there who are willfully ignorant of this. A very common response with incest is not to help anyone at first because the perpetrator puts the victim in a situation where they believe that speaking out will cause harm to themselves and their family. And in many cases, when a victim does speak out, they are pressured by the family to keep it quiet, and police are verboten, sometimes to the point that the victim is threatened with homelessness if they report. Neither of these situations are unrealistic, and both are horrifying perspective to even imagine going through. Then there's this little gem of a section. Health records shall be available to the district attorney or the judicial circuit in which the act of abortion occurs, or the woman upon whom an abortion is performed resides. Let's compare this to what the original law said. Hospital or licensed health facility records shall be available to the district attorney of the judicial circuit in which the hospital or health facility is located. Immediately, two things should concern not just people who are getting abortions. While the previous law allowed for records of facilities such as who works there, how many patients were seen, what kind of drugs were prescribed, what procedures were performed, it didn't it doesn't seem to have allowed personal information. This new bill is written to specifically allow prosecutors to access patient records. If this one is allowed to stand, then it opens the door for other such record searches for issues or conditions that the government might not want. Second, the original law said that the judicial circuit where the procedure happened was where the records could be requested. The new law states that it can be this or wherever the person who got the abortion resides. Growing up as a pro-life nutter, I was up to date on all the arguments against abortion, and one I remember hearing often was one against the federal overreach of Roe v. Wade. Rather than allow individual states to make the decisions, they allowed the government to do so and took away state rights. If a local state wanted to ban abortion, it should be allowed to without federal interference. When it was argued, what about people who wanted an abortion, who lived in those states? The argument I heard, and one that I was trained to give, was, well, if you need an abortion, you can travel to a state that allows it, which is an especially ableist and classic remark when you think about it. This law is working on allowing an abortion ban and making it so if you go somewhere else to get one, they can get your records for prosecution. One might argue that reading the law like this is a stretch, and there is no way that the state would prosecute someone who got an abortion. Section H. It shall be an affirmative defense to prosecution under this article if 6. A woman sought an abortion because she reasonably believed that an abortion was the only way to prevent a medical emergency. The fact that they added affirmative defense pleas into the law indicates that they fully plan on this law being prosecutable to those who get an abortion. Also, cis-sexist language. What is an affirmative defense? It's a defense where someone states that yes, they are guilty of breaking the law, but it should not apply here because... It should be noted that an affirmative defense, even when successfully accepted by the court and jury, does not get a defendant off scot-free. Often there are still consequences. And when you consider that the fact that they consider an embryo a legal person with all the rights thereof, they will not be prosecuting for abortion. They will be prosecuting for murder. Now, when you're in a state and you take someone to another state with a specific reason of murdering them in that other state, you and those who help you can be charged with conspiracy. And if the citizen of one state is killed in another state, the first state can prosecute if it can be shown that the crime started in their state. I am sure if I was a lawyer, I could write a lot more about some of the consequences of this section 4. If you'd like to read a lawmaker's speech and further analysis of it, I've included a speech interview of Georgia State Senator Jen Jordan in my notes. She makes some claims that I cannot verify, but she is someone who voted on this law, so I would suspect her words have some truth to them. Now, let's whiz through the rest of the sections. Section 5 is a bone thrown to people who are being shafted in this bill. They are now able to sue the person who got them pregnant for child support and medical expenses that happened before the birth. Section 6 is a rewriting of the part of Georgia law that indicates that the legal recourse, i.e. civil suits, a parent can bring against another for the homicide of their child. It is written here to allow this to include unborn children. It should be noted that this event is considered a homicide, as in things people are prosecuted for. Section 7 is a part of the Georgia law that tells the person who is to perform the abortion what they are to say to the person getting an abortion 24 hours before the abortion. Yes, they are cutting the time for an abortion down to 6 weeks, and they are still keeping the 24-hour hold. This is a small change where the medical person must tell the pregnant person if there is a presence of a detectable human heartbeat. Section 8 deals with the material that must be given to the person seeking an abortion. It is to add to them that as early as 6 weeks gestation, an unborn child may have a detectable human heartbeat. Section 9 is a repealing of Code Section 31-9A-6.1, which removes some of the penalties for medical personnel if they do not get the information to someone seeking an abortion. If I'm understanding this part right, it is a bit dense here and it requires jumping to multiple sections of the Georgia law to fully understand. Section 10 adds to this law what was taken out by Section 9. Section 11 tells a medical person who performs an abortion what they have to report to the state upon completion of an abortion, with additional rules being added for the heartbeat law. Section 12 allows people to claim unborn children on their taxes. Yes, you now get to claim your embryo as a dependent. Section 13 gives people the right to fight against any action challenging the constitutionality of any portion of this act. I imagine they mean it legally and not with guns. Section 14 states that the portions of this act are severable, which means that if one part of it is ruled unconstitutional, the other parts still stand. Section 15 makes this act effective January 1st, 2020. Why? Because now that the embryos are dependents, they have to wait to start at the beginning of the year for tax purposes. And finally, Section 16 states that if there are any laws in conflict with this act that they missed, they are repealed. I hope in my review of this law I've chilled your bones some. It is a terrible law, badly written, and it goes against medical and scientific advice. And one thing that makes it even scarier is that 4 or 5 other states are trying to pass laws very similar to this. All of them are being written with the eye of making it to the Supreme Court and overturning all or part of Roe v. Wade. This was tried already once in North Dakota in 2015, and it failed. I only hope it happens again. And for a final word, I cannot carry a child. I am not cis, and barring a medical breakthrough, which I'd probably be too old for anyway, I will never have to face the choice of an abortion. So in speaking out, I am not trying to defend my rights. Although I wish I was. Instead, I'm speaking out for the rights of those who can and who would have to make this decision. I will never have to be forced to choose if I would or would not get an abortion. But if I was faced with a choice, I would want to have the full freedom to do whatever I choose to do. And I believe it is for the best that everyone else can do so as well. Thank you all for watching. Sorry about the little bit of breaking up at the end. I would record again, but I'm pretty sure I would do it again. When I think about not being able to have children, it sometimes gets to me. Anyway, make sure you like and subscribe, and be sure to ring that bell so that you get notified next time I put up a video. If you have anything to talk about, please put it in my comments. As my usual policy for my comments, if there are comments below about being trans and making fun of trans people, asking if I'm really trans, asking if I'm a man in a dress, anything like that will be deleted. I have plenty of trans videos where you can ask me questions, but this is not one of them. Instead, keep your comments to the issue in this video. I try to read and reply to every comment, so I really like seeing them. You can also follow me on Twitter at atheist_t_girl. And as always, I hope y'all have a great day.